What's up, everybody? We have some breaking news today, and this is some good news out of the Ninth Circuit Court of Appeals, which is not one that we usually get pro-Second Amendment good news out of. Usually, we're always talking about how the Ninth Circuit is the Ninth Circus. We are talking about the California 1 in 30 rule. So one firearm every 30 days was the law of the land. And it has been struck down, which is fantastic. I'm going to walk you through what happened here. But the takeaway here is if you are a resident of the state of California, which I know that many of you are, I'm sorry that you live in such a terrible place, but you guys are fighting the good fight out there. You no longer live under the 1 in 30 rule as of right this second. So we're going to hear a quick word from today's sponsor, and then I'll walk you through what exactly happened and what this means, not only for people in the state of California, the people under the Ninth Circuit, but also the country as a whole. Today's video is brought to you by XS Sights, and I've been using XS for almost a decade now, and I will admit that when I first started being introduced to XS Sights, I didn't get it. It wasn't until I took a force on force class that was a low light class that I was like, oh, there's no other sight in the world. This is what we have to use. And I've been using them ever since. I gravitate towards their big dot sights for my pistols, but the same technology is available in the regular dot size. XS continuously pushes the envelope, such to the point that they even recently came out with fiber optic sights for those people who are completely wrong about how to use sights. Special thanks to XS for making today's video possible. Okay, so as far as I understand it, because I don't follow California politics very well, I have given myself a quick write-out, and as far as I have been able to really understand how things happen in the state of California. So back in March, a district court heard the case, and they solidly decided in the favor of the Second Amendment. That case was brought by a whole bunch of people, but most notably would be the Second Amendment Foundation and the Firearms Policy Coalition. You guys have heard those names multiple times before. I'll have a front page on the judgment from the district court. So from there, they won at the district court level, and that was appealed immediately by the state of California. Bonta out there seems to be pretty quick to do the appeals and not so quick to do the rest of his job. But anyway, they appealed up to the Ninth Circuit, and when you appeal up to the Ninth Circuit, and you guys can correct me if I'm wrong out there, it goes to like a special 3-judge panel, which is weird. That appeals panel actually said that it was constitutional, and they agreed with the state. It was a 2-1 decision, and they granted the stay. That was then appealed up to an actual 3-judge panel up to the Ninth Circuit, and that is what we just got down after. I was going to do a video on this probably tomorrow as it related to the arguments that were made at the Ninth Circuit because I thought they were pretty solid.
30 days is really a short period of time, and if we look at, for example, in this particular case, this case has been pending since 2020, the plaintiffs would have been able to purchase dozens of firearms with that.
Well, counsel, I mean, I'm trying to understand sort of a fundamental premise here. The Supreme Court has said that for Second Amendment cases, we can look by analogy to other rights that citizens have, including First Amendment rights, et cetera. It would be absurd to think that a government could say, you can only buy 1 book a month because we want to make sure that you really understand the books that you read. Or you can only attend 1 protest a month because, you know, there are some societal drawbacks to having protests, and so we want to kind of space those out. People would say that's absurd. So if we conclude that you have a right to bear arms, and we conclude that that's not the right to bear an arm, but could be plural, like what is the basis in the law anywhere for the idea that you could say to someone, yes, you have this right, but we're going to control how frequently or how often you get to exercise it?
Well, the historical analogs that we've presented do show that a robust record of commercial regulations that do have the ability to
basically failed hard. After one day, the Ninth Circuit 3-judge panel said, yeah, this is out of here. Unanimous decision lifting the stay on the district court decision. So that is going to go through. Now, as far as my people out in California, what I will say to you is you can now go and say, I want X number of whatever, and walk into any FFL in the state, and they can legally sell you whatever property it is that you want. There are a few caveats there. I know that federally there is a multiple handgun transfer form. As a licensed federal firearms licensee, if you buy more than one handgun, you will have to fill out that form, and it would not surprise me if that form triggers some kind of special visit for you from your local law enforcement. It wouldn't surprise me whatsoever if they aren't in league with the ATF and the ATF sends them multiple handgun transfer forms and they pay you a visit. Just keep in mind that that is very likely to happen. We know that that happens in the states that do this with multiple semi-automatic rifles. If you buy multiple semi-automatic rifles, and there's like 3 states that do it, there's a special form that is very similar to the multiple handgun transfer form, and those states absolutely do show up and check you out. So I'm not sure if that is triggered by lower receivers or not. So if you walk in and say, hey, I want multiple lower receivers, I don't know that that is triggered in those states. I don't know if it's triggered like that in California. That is something that you would have to ask somebody at your shop. It wouldn't surprise me if California hasn't instituted something like that. As always, you don't have to talk to the cops. Just throwing that out there. What goes on from here? I think that just given the record, I assume that either Monday, later today, this weekend, or Monday, you'll see an appeal by the state of California to push this up to a full appeal. Well, actually, yeah, I assume that they will push that up to a full appeal, and that would, in my mind, go up to an en banc panel, and they would decide there. And the thing about that is, based on what we've seen from the Ninth Circuit here, they denied the stay. Would they take the case if they say that the plaintiffs are most likely to succeed on the merits? If the opinion of the court is already that the plaintiffs are likely to succeed, would they even take the case? I don't know. That would, of course, depend on the judges making the individual decision to take the case. This is one of those ones that's kind of specific to California. It wouldn't surprise me whatsoever if they don't take it and California just cuts their losses on that one. Because they're getting hit from a couple different angles. It wouldn't surprise me if they just let it die at the district court, at the district court level, and let the decision stand. But they might try to push it up to the Ninth Circuit. And if they push it up to the Ninth Circuit and they were to win, well, you know that Firearms Policy Coalition and Second Amendment Foundation are going to not let that one die. So they'll take that up to the Supreme Court. Whether we win, lose, or draw at the whatever level it is, I always think that it's great that we've got a lawsuit in action in the courts, regardless of what the issue is, because ultimately, I know that our people are committed to taking those lawsuits all the way. It would be most wise, most strategic of them to allow this one to die, because whenever you get something like this that goes up to the highest court in the land, there's always an opportunity for it to have broad-reaching consequences. So remember that this whole series of lawsuits that you've seen over the course of the last several years were off of a licensing scheme that New York was perpetrating. And that has opened the floodgates to require text, history, and tradition of firearms regulation in the United States for all Second Amendment related infringements. So you want to make our day? Go ahead and appeal this this decision. Now, what does this mean for nationwide? Well, if California is kind of the seed point for a lot of different weird ideas as it relates to Second Amendment infringements. We say that if it starts in California, it kind of bleeds across. For us to have an opportunity to stop something like this now before it starts bleeding into the surrounding states and perpetuates itself in some of the other blue regions of the country is a good thing. We've seen that the Ninth Circuit, which again we call the Ninth Circus, which is the most leftist circuit court in the United States, decides that this is unconstitutional under the Supreme Court's direction. Not a whole lot of other locales are going to pick up this sort of thing because they know it's a non-starter, and they know that organizations like Second Amendment Foundation and Firearms Policy Coalition are going to be right there to kick them in the teeth immediately. And again, make our day, allow us to sue you and take you all the way up as far as we can get it to set as much precedent as we can that this kind of activity is wrong. So as far as nationwide is concerned, I would say that this is probably the last vestige that you're going to see for monthly limitations in the United States, which I think is a very, very positive thing. And that's all I got for you guys today. Thank you very much for tuning in. Let me know what you think about this in the comment section down below.